Hello everyone, welcome to this Collier Bristow podcast on Directors' Duties. I am Nichola Leach, a Senior Associate in the Commercial Disputes team, and I am joined by Helen Ingram, an Associate in our Corporate and Commercial team.
Hi there.
As part of this podcast, we will be looking at what the Directors' duties are and to whom they are owed. We will then move on to consider what the implication of those duties can be, how they should be borne in mind in the day-to-day running of a company, and what could happen if those duties are not adhered to. So a good place probably to start is to ask the question, well, what are those directors' duties? And they fall into the broad categories of being either statutory duties, and then there's other uncodified duties. We will take you first on a high-level run-through of those statutory duties that directors are subject to. And these are found in the Companies Act 2006, and we will be looking specifically at the 7 general duties at sections 171 to 177 of the Act. I'm going to take them in no particular order of importance. I'm simply going through them with Helen as they appear in the Act. And the first duty on a director is to act within their powers. And that essentially means that they need to act in accordance with the company's constitution. And that constitution can be set out in a number of documents, including the Articles of Association, as well as certain resolutions or decisions by members of the company. So it's really important that directors keep these documents at the forefront of their minds, particularly when they're making decisions and, to check what they're doing is within their powers to do so. In addition, the powers must only be exercised for the purposes for which they were conferred, and this must be determined in the context of the specific situation under consideration. A second duty directors have is to promote the success of the company for the benefit of the members of the company as a whole. The Companies Act sets out various factors to consider in this regard. So, for example, a director may need to consider the likely consequences of any decision in the long term, how that decision might affect the interests of the company's employees, whether the decision fosters the company's business relationships with their suppliers, customers, and other individuals or companies they associate with. And the directors also need to act fairly between the shareholders of the company. For example, they cannot treat one shareholder preferentially when making a decision because that shareholder just happens to be a very close friend. The decision they're making must be for the benefit of the shareholders as a whole. And I just want to point out that that list I've given is not an exhaustive list. It's just some of the factors that a director may wish to consider when promoting the success of the company. A third duty directors will find themselves subject to is to exercise independent judgment. In short, they should not allow their independent judgment to be compromised, and they should always make their own decisions. Although this does not prevent a director from acting in accordance with the company's constitution or in accordance with an agreement which the company has entered into. Whilst the director can take advice on the decision they're making, ultimately they must exercise their own independent judgment in deciding whether to follow that advice. They shouldn't be influenced by their own feelings or consideration of how the decision may impact on them personally. And also when exercising that independent judgment, they should keep in mind the former duty I referred to, which is to promote the success of the company for the benefit of the members as a whole.
Definitely. There's also a few other statutory duties as well. So directors are required to exercise reasonable care, skill and diligence, which effectively means that it's an objective test really to consider what would be the level of knowledge, skill, experience that we would reasonably expect of a person carrying out the kind of functions that a director would carry out? And are they operating to that standard? And then, of course, if the director has any particular, say, specialist experience or skill which might be relevant, then they will be expected to uphold that as well. If they are, let's say, a lawyer, then and have particular knowledge over contract law, for example, they will be expected to bring that to bear in their work as a director. There's also three other duties that you can somewhat class together. So to avoid conflicts of interest, not to accept benefits from third parties and to declare any interest that a director might have in a transaction or an arrangement with the company. Essentially, as Nicola's already mentioned, or as you've already mentioned, Nichola, I should say, directors are supposed to act for the benefit of the shareholders, and therefore they shouldn't be allowing themselves to get into situations where they stand to benefit from something the company's doing without disclosing that. Now, it might be that they need to, if that's the case, it might be that they need to avoid the situation, so recuse themselves from participating in any votes at a board meeting on that particular subject, or it can be the case that the company's articles of association permit either shareholders or in some instances directors who are independent and don't have the same conflict of interest to effectively authorise the conflict so the directors can continue to participate. That's going to be a sort of a fact by fact, a case by case decision that needs to be taken depending on what exactly the interesting question is. And just turning as well to the requirement not to accept benefits from third parties. I mean, the obvious example that springs to mind would be any sort of bribe. We're aware that generally we don't really want people in business to be taking bribes, but particularly for directors. But the obligation is broader than that as well. So any sort of favourable profit that might be offered to them, or any kind of advantage that might be offered to them as a result of a particular decision, they are under a duty not to accept that. Well, with a carve out that if the benefit in question isn't likely to give rise to any conflict of interest, then they're free to go ahead with that. But again, it's always a question of what will the impact be on the company, and they are under a duty to put that as a sort of an overarching consideration, really. But as Nichola mentioned at the start, those are the statutory duties found in the Companies Act 2006. Directors are also subject to what are known as uncodified duties, so duties not contained in any sort of legislation. One easy example of that is they're under a duty not to misapply a company's funds by paying unlawful dividends or any sort of returns of capital. The shareholders are going to want the benefit of those for themselves, so it's probably quite a sensible duty, really. That's just one example. Actually, a lot of the uncodified duties have already been absorbed into the Companies Act. We've also got, though, fiduciary duties, Nicola, which I think you're going to touch on.
Yeah, thanks, Helen. Yeah, so fiduciary duties are quite interesting, really, and it's something I come across quite a lot when I'm litigating these types of claims. You know, a claim will have in there that a director has breached his fiduciary duty. Now, it's a slightly amorphous concept, actually, and one which can be quite difficult to explain. But in short, it's a reflection of a sort of a relationship of trust and loyalty between the director, the company, its members, and its stakeholders. And it's so, in a way, it may seem obvious that is implied to the relationship, into the relationship, but and you think, well, obviously we're all in a company together, of course we behave in a loyal and a trustful manner, and we all have confidence in each other. But I think quite often people don't appreciate this is actually a duty and a requirement which can carry legal implications on them. So directors are required to act in good faith in the best interest of the company, and this fiduciary duty element, it does overlap with the sort of the statutory duties, but just reinforces that point that directors are required to demonstrate the utmost best behaviour, and the people they're running the company for should be able to have trust in the way they carry out their duties.
Definitely, I think it's easy to forget that being a company director can it can take a lot of different forms, from the sort of huge global companies that, sort of brand names that we're all aware of, right down to smaller sort of family-owned businesses or whatever it might be. And actually, I certainly find in my work, it's not necessarily a given that all directors are equally familiar with, or all people who are contemplating becoming a director, I should say, are equally familiar with the duties that they have, which I think is why we thought we'd sort of kick this off with giving you a bit of a summary of what the duties are and why you should be paying attention to them, really.
Yeah, no, I think that's right, Helen. And I think actually just sort of two points I want to pick up from actually on what you've said. So the first just to remember is that there can be directors on duties in other legislation. So it can be health and safety. But for the purpose of today's discussion, we're not going to go into detail on that. But I just want to pick up on the second point you raised about how these duties pervade, whether you're a global entity or a small family run business. And that's really important because often what we come across quite a lot is where you've got shareholder directors. So you've got companies whereby the shareholder and the director are actually the same individuals. And that can be really confusing and it can lead to boundaries being blurred. But it's really important that from company law perspective, those two things are seen very differently. And you may need to be the shareholder at one point and you may need to be the director at another point. Now, I guess broadly speaking, company law requires that directors make their decisions by way of a board meeting and, shareholders usually do them by way of resolution. So when it comes to the point of making a decision, it can often be quite easy to see which capacity you're acting in. But I think just in the sort of on a day-to-day basis, you do need to give some consideration to that. I mean, in short, I guess a director manages the company on a day-to-day basis in line with the aforementioned duties we've just said. Whereas on the other hand, the shareholders own and control the company and they're not responsible for the day-to-day running of the company. They generally make like the larger decisions. So if you're talking about maybe looking at issuing shares or considering an investment opportunity, that is something more in line with perhaps your exercising of your shareholder hat, to use that phrase. But if you're talking about entering into a new contract on behalf of the company, or you might be looking at more from your director's duties and having to consider whether that contract is something to enter into in line with both the statutory duties and the fiduciary duties that we've mentioned. And I think a really important point to make is that particularly where you are the shareholder director, is really important to sort of record your actions as a director and make clear when you're acting in that capacity. So, directors can quite simply demonstrate that they've acted in their director capacity by and fulfilled their statutory duties by just keeping careful records of decisions that have been made, the process went through, the reasoning for the decision. And that's usually done via, board meetings and notes and that but, quite often companies don't necessarily have like formal processes in place, where they are recording these meetings and notes. And, if it's a family business, it could be a discussion around, around the breakfast table, for example. So it's really important that even in those circumstances, people do think back about, well, am I keeping careful records of why we've made these decisions? Because, as Helen and I will come on to discuss, those decisions can in due course, as a director, come under scrutiny, and you need to make sure you know what you've done.
No, I completely agree, and I think you sort of mentioned it there. I think the idea of using this kind of idea of what hat am I wearing when I make this decision, it does. I've certainly had clients who found it really helpful to assist them in working out what is it they need to be considering at any given point. Am I deciding this in my capacity as a director, my role as a director, or in my role as a shareholder? It's certainly a question that we get questions from clients, and we're advising on pretty regularly, to be honest, whether that's in a sort of an isolated, we've got this decision to make and we're not quite sure how to go about it way, or in the context of a bigger deal, we're looking to sell the shares in our business or sell some of them or all of, whether it's some of them or all of them, and how do we navigate that, obviously generally, but also within this question of this split between shareholders and directors. So it's an important one, and I think it's one that perhaps it's good to spend a bit of time thinking about, which I think sort of leads us nicely onto this question that you sort of touched on, Nichola, which is we've talked about the fact that directors are subject to these duties, but actually to whom are the duties owed?
Yeah, no, I agree, Helen, because I think often there can be sort of misgivings and misunderstandings around this. And, it can particularly become complicated where you've got the shareholder and the director being the same individual. But in short, the simple answer is, the duties are owed to the company. They are not owed to the shareholders. Now, there may be circumstances where a shareholder might be able to enforce those duties and take steps in respect of when those direct duties are being breached or not being followed, and that's something we'll explore a bit later in this podcast. But the fundamental point to take away is that these duties are owed to the company. And I just sort of add one slight caveat to that as well is if you've got a situation where a director knows or ought to know that a company may be becoming insolvent, then at that point then the duties will become owed to the interests of the creditors as a whole, as a category. But yeah, I mean, I think that's obviously a point which can often get lost because directors feel they're very answerable to the shareholders, the people they're trying to make the profit for, but they can forget that actually it is the company they owe these duties to.
No, definitely. I think it's one that can really take people by surprise, because I think a lot of people understandably assume that, as you say, we answer to the shareholders and they're the ones that receive the dividends or have the entitlement to capital on a winding up, whatever it might be. But the company rather, not sure when we dropped a T into the word, but the company is a separate legal entity and has to be considered in its own right. So the other point that I think people can find surprising is actually who is subject to these duties. Now, I mean, I know the whole premise of this is that it's the directors that are subject to it, and that's absolutely true. I'm not undermining the name of this podcast, but who actually constitutes a director for these purposes is a little broader than I think people might expect. So you have your normal directors, your what are known as in legal terms de jure directors, who are sort of validly appointed directors. They'll be the people whose names you'll see on Companies House, sort of all set up in a very normal manner. But there are also two other classes of directors which can take people a bit by surprise. You've got what are known as de facto directors. Now, these can be individuals who haven't been sort of formally appointed as directors, but they actually undertake those functions for a particular company. It's quite a fact-sensitive scenario, so it's sort of difficult to give you a single. We do often get asked by clients, how can I tell if I'm a de facto director? And there's no sort of single test that you can apply for that. But it's basically anyone who, if you were to look at them as an outsider coming into the company, does it look like they are the person who's acting as a director, who's taking decisions at that level, who has that level of authority and control within the business. So they will be subject to these duties as well. And then the third class of people are known as shadow directors, which is less ominous than it sounds, at least in my opinion. But this is a person who might give directions and instructions to the directors, and the directors will normally they'll be accustomed to, they will normally comply with these instructions. Now, that's not the same as taking professional advice. So if you're consulting a lawyer or an accountant, anyone along those lines, it's not. Directors are entitled to seek professional advice. It's important that they can seek it, in fact. But this might be a sort of a very influential person within the business who what they say goes, basically, that if they're the ones who are sort of behind the scenes sort of giving instructions to the directors and the directors are carrying them out, then they need to consider whether they might be a shadow director. Now, in that instance, the duties will only apply to them to the extent that they're relevant. It's not a sort of uniform case that every single duty will apply absolutely to every shadow director. It will be a sort of case-by-case scenario, and you, if you're concerned about that in the context of, let's say, a big deal of some form of investor coming in, then that's the sort of thing you'd really want to be taking advice on from solicitors. I think the other thing that can take people by surprise is discovering that some of these duties actually continue after a person ceases to be a director. your duty to avoid conflicts of interest and your duty not to accept benefits from third parties. Unfortunately, it's not a workaround to say that you'll accept a benefit for, let's say, totally made up scenario here, but exercising your vote in a certain way. But you can't get around the duty by saying, well, you have to wait and give me whatever the benefit is after I've stopped being a director. Actually, that's going to carry on, unfortunately, which is probably sensible, because we want, as we said earlier on, we really do want to make sure our directors are acting for the benefit of the company and acting independently. So it's just something really to be aware of, that it's a commitment that you're making for slightly longer than you might think of. And not to be intimidated by, but not to be underestimated either.
Yeah, I think that's really important, Helen, as well, because actually there was a recent sort of case law as well, and I won't go into details of the case involved, but one point that came up in this case was whether sort of a director's duties were extinguished, on a company being pasted to liquidation or administration. And I think an important point to note is that even if a company goes into liquidation or administration, even when the control of the company passes to the office holder, and you as a director have your powers to run the company obviously get curtailed and are severely limited, that doesn't then give you free rein to act however you want, and you are still you're still cognizant of those duties, and you are still pinned down by them. So for example, if you were looking at purchasing a company's asset, for example, as part of that liquidation or administration, you need to think about that. You need to be aware that you need to then go back to the start. That is it in the interest of the company for you to acquire the asset? And you might want to acquire it for as low as possible, but there's still duties existing to creditors of the company. So it's just something to keep in mind that then even if you're still involved in a company after it drops into administration or liquidation, you're still subject to your duties, and you do need to give serious consideration to those points.
Yeah, which I suppose does make sense, doesn't it? Because actually you've got an administrator or a liquidator there who's trying to recover as much as possible of the value of the company for the shareholders, and you don't want the directors there restricting your ability to do that, shall we say?
Exactly.
So I see what you mean. It is an interesting point, and actually something I think you've faced fairly often, Nichola, is the question of what happens if a director does breach their duties, and what consequences they might face. Is that right?
Yeah, no, that is right, Helen. I mean, directors can face claims ultimately in a personal capacity for breach of those duties. And I'll look initially perhaps just at the sort of the civil liability side, which is what we at Collier Bristow deal with more. And one point to make though, when I'm sort of preamble to discussing this is, directors have civil liability, but just to point out that, a claim against a director is not just limited to a breach of those duties we've discussed during today's podcast. It can also be claims, you can face claims for negligence, for deceit, for fraud, but the overriding message is that, directors can face personal liability, which I think, is something they often, aren't aware of, and they can face these consequences. And the remedies a director can, if found guilty of a breach of those duties or on the claim being pursued against them, the remedies available are quite far-reaching. So that's just something to be aware of. But perhaps it's helpful if I maybe sort of on a high level, I won't go into too much detail, otherwise we might be here quite a while, but perhaps I'll just say, I think that the claims, largely speaking, can fall into claims by three groups of people against the director. So taking them in order, I mean, logically, the first thing would be, well, it would be a claim by the company. It's the company that could have suffered loss as a result of the conduct of the director, and therefore, the company can bring a claim against the director for that loss they have suffered, and as a result of the director's breach and the director's conduct. But this is actually quite an interesting point, because quite often the wrongdoer can be in control of the company. So it's highly unlikely you're going to get a situation where a director says, yes, sorry, I entered into this transaction, it's caused a big loss, really wasn't in the interest of the company for me to enter into it, but don't worry, I'm going to sue myself for it. I mean, they're not going to...
that's going to give the shareholders much comfort, is it?
No, exactly. So that's obviously, we're not going to get, rarely, they're not going to encourage a company to pursue a claim, which is essentially against themselves. So
I suppose as well, that's assuming that the director in question has left any money in the company to use for that litigation.
Yeah, exactly. So and that's a good point. The company may not even have the means to bring the claim at that point. And so I think an important point to flag therefore is, a different approach might be required. And then this comes via the shareholders. So the shareholders themselves don't actually have a right to claim against the director for any loss, and they believe they may have suffered because of the breach. Shareholders are essentially prevented from recovering reflected losses. And to just explain that in a bit more detail, if a director breaches its duty, it's the company who has suffered the loss, and the shareholders suffer what's referred to as a reflective loss, because their shares are worth less than they perhaps may otherwise have been. But the shareholder can't pursue that. It's not the shareholder's claim, it's the company's claim to pursue. So what's happened is the law has basically developed to allow shareholders to step into the company's shoes and to therefore pursue the claims on the company's behalf. And that's referred to as a derivative action. Now, again, if I go into the ins and outs of derivative actions, it is quite subject to case law as to, and I'll touch on this in a bit, but we'll be here quite a while if I go into huge amounts of detail on it. So the way this process works of bringing a derivative claim is the shareholder will go to the court and they will issue the claim. Now, the court doesn't just immediately allow that claim to proceed. It first needs to be certain that it's not an unmeritorious claim. It wants to be satisfied that there is some merit, to the claim, because
there's a bit of substance to it.
Exactly, because sometimes, shareholders can just be disgruntled. A company could have suffered a loss, their shareholding price could have gone down, and it could be no fault of the director at all. So the court needs to be convinced that there is, at least some merit to the case before it allows it to go forward. And then once it's, if it's gone through that stage, then what happens is the claim proceeds to sort of a full hearing before the court on permission on whether or not it can proceed. Now, there's a lot of competing factors to be considered in that regard, and as I say, I'm not going to go into that.
That's a separate podcast, right?
Yeah, exactly. It's a whole it's a whole series of podcasts, I think. If we were to go into that, but I think just two important points really to flag is the court will definitely refuse permission if a director is acting in accordance with its duty to promote the success of a company, and they would not seek to continue the claim. And the second is, if there's a proposed act or omission which relates to the derivative action, and it's already taken place, and it was either authorised or has been ratified since it occurred, then that would also be a bar to pursuing this derivative action. And this obviously does seem like a bit of a complicated procedure, and you might think shareholders might be like, oh, really, it's I've got a lot of hurdles to jump through here before I even have a shot at maybe be getting something. But the court needs to be convinced that the shareholder is bringing the claim for the benefit of the company, and it's not got some ulterior motive in all of this. So that's sort of a bit of almost an initial filtering process to stop unmeritorious claims. And I think just sort of another angle to very touch on very briefly with the claims by shareholders is that breaches of directors' duties can also form part of the matrix or the basis of what are referred to as unfair prejudice petitions brought by shareholders. And again, unfair prejudice petitions are a whole separate podcast, but just for the benefit of those listening, that's where a member of a company can apply to the court for relief on the grounds that the company's affairs are being conducted in a way that is unfairly prejudicial to the interests of the members generally, or some parts of the members of the company, including themselves. And that's it's often a remedy or a cause of action pursued potentially by minority shareholders, and that entitles them to all sorts of potential remedies. But the main thing would be the shareholder who has brought the petition seeks an order that their shares in the company are purchased at a fair value. But that's not the only order that can be sought. Actually, one of the orders that can be sought is, permission to bring a derivative action. So that's just a point to flag. On the other way, sort of directors' duties and the breaches, or just general breaches by directors, may sort of feed into shareholder claims. But I think that's all I'm going to say on that for the moment. So that really takes us then to the sort of the third category of, potential claimants against a director. And those are claims by a liquidator or an administrator. And basically, once a company's become insolvent, there may be a misfeasance claim if a director has misapplied or retained company's money or property in breach of their duties. Now, one point just to note is a misfeasance claim isn't it's not a new cause of action. It's just a means of bringing an existing cause of action. So it's not a claim in its own right. You'd be the liquidator or the administrator would be bringing a claim which probably already existed, and it's bringing it against the directors in this situation. Now, conduct which can be sort of subject of these misfeasance applications is really far-reaching. So again, it could be fraud, it can be breaches of your statutory duty, it can be failure to exercise, skill and care. So for example, if a company is selling a substantial asset and a director has failed to obtain a valuation before doing that, and it transpires they've sold at a significant undervalue, that could be something a liquidator or administrator looks to pursue against the director in due course, because they're trying to recover as much as possible for the creditors of the company. It can be if it transpires that unlawful dividends have been paid, or secret profits. So the circumstances giving rise to these misfeasance claims, are quite broad ranging. And I think sort of just a point to note is, normally you need to show loss to the company to be able to bring those claims, but there is a few exceptions to that. So it can be, a claim for an account of payment of profits. So that's where the company hasn't lost anything, but the director has gained something. That would allow these claims to be brought, and also in the context of preference claims. But broadly speaking, that's sort of claimed by administrators and liquidators. And the court may order, for example, in these circumstances, that the officer should repay or restore or account for the money or property with interest, or they may be required to contribute a sum to the company's assets by way of of compensation, or any order the court thinks is just and appropriate. So the consequences can be quite severe, but also this is considering situations where there is quite great wrongs committed by directors. And I think sort of, I've obviously tried to just one other point which sort of springs to mind actually in sort of the current environment is, I've spoken largely about the three categories we think the claims generally fall into, claims brought by a company, claims brought by shareholders, and liquidators or administrators. I think a point to flag is, they're not the sole people who pursue claims against directors. For example, you could maybe have, say, a director oversaw a third party enter into a contract between, a third party and the company. But as part of that negotiation, the director misrepresented something, fraudulently or negligently, the director in that situation may face a claim. And I think another point, which is, it's early stages yet, but we're sort of seeing soundings of it in the news at the moment, is where, there's suspected to be quite a lot of fraud around the COVID-19 loans and support packages given out by companies.
There's been a fair amount of that in the press, hasn't there?
Yeah, a lot. And I think this may actually, hopefully not, but it's something which again could lead to, knocking on the doors of directors, because I think what's happening is, is the Beebles and the Seables loans, but lenders are increasing. Sorry, not lenders. Apologies. The government is not necessarily honouring some of the guarantees to lenders, which is a massive exposure for lenders now who've provided those loans. So the lenders who've provided these COVID-19 support loans for businesses are going to need to look for recourse. And so maybe we might get a situation where if they think a director has misrepresented the financial position of the company to get the loan, or maybe they're concerned actually that the loan's not been used for the purpose represented, then perhaps we might get lenders pursuing claims personally against directors. And that's just something to flag. And just a final point, which I haven't touched on, and I promise it's not all doom and gloom. This, and Helen will explain how in a minute. But a point just to flag is directors can have criminal liability. So for example, for fraudulent trading, if they've knowingly been party to allowing the business to carry on with the intention to defraud creditors, then that can be a criminal offence. So, and there's lots of other examples which I won't go to, but, the breach of these duties as a director can carry criminal liability. But I'll try and let Helen shed a more positive light on some of this.
Well, yeah, I think it's worth saying at this point that, where a director has acted within their powers, has acted appropriately, then they're not going to necessarily assume personal liability. I mean, I think it's important to know what one could face if you don't give due consideration to your duties. But actually, if you've acted properly, and to use your example of the third party and who's entered into a contract with the company, and it's not that the director has misrepresented something, but actually it's just that something's gone wrong. Unfortunately, at that point, the right party to any claim by that third party will be the company rather than the directors. The directors really are only going to get brought into this if they have, if their actions were outside of what they should have been. If that's a clear enough way of putting it, if they've breached their duties, if they've committed fraud, if they've met the standard for negligence, then at that point the eyes will turn towards the directors, but it's not necessarily the starting point, I suppose, is what I'm trying to get at. So hopefully a bit of a ray of sunshine there.
Yeah, after the voice of doom and gloom here. I mean, I think maybe one thing, just to pick on what you had said then, Helen. Okay, so we say, it's not always personal liability, and these things can happen by mistake. So is there anything that can be done where a mistake does occur?
Yeah, there absolutely can be ways to fix things, and I think that's a really good question to ask. If you come to a realization that actually maybe by accident you as a director have done something perhaps you shouldn't, or you haven't quite followed the right procedure, or whatever it might be, there's two main ways really that you can go about resolving that, and potentially the simplest, depending on the size of the company in question, is to ask the shareholders to ratify the breach. What I mean here by ratify is basically to authorize it after the fact. Now there are conditions to that. So an easy example is that shareholders can't authorize anything which is unlawful, because it's not for them to decide when the law does or doesn't apply. And as a general rule, they can't ratify the directors acting outside the company's constitution, which, as you mentioned earlier, is normally made up by the company's articles of association and various shareholders' resolutions that may have been passed. So there are limitations to what can be done, but the shareholders can absolutely be asked to step in, to come along sort of behind the directors and say, in this instance, we'll approve it. So the second option is you can apply to the court for relief. So you go before the court and explain the situation, and ask the court effectively to waive the breach, I suppose, is one way of putting it. So that actually, although it's not what you should have done, there are workarounds, provided that it's not an egregious breach of some form, or as I say, it's not something that's completely illegal. So I definitely think there is comfort to be taken that actually a director who is genuinely trying to uphold their duties, trying to do the right thing, but act in the interest of the company, even if things do go a bit wrong, there's solutions at hand. And again, if that's the sort of point at which I would be saying to someone, if you're concerned by that, best thing to do is talk to a solicitor. Come and talk to us at Collier Bristow, and we can help you work out what needs to be done. I mean, Nichola, I think unless you had anything further to add, I think that sort of covers our introduction to directors' duties, all the highs and lows of working out what it is you're signing up for. But hopefully it's helpful for people to understand what actually being a director entails, because it's as we said at the start, it's an important commitment.
No, I think that's right, Helen. I think, hopefully this has just given people listening sort of an insight into what they're signing up to. Director isn't just a title. It carries with it obligations and duties, but the majority of directors will exercise those duties right. There can be consequences if there's not, but if it's, as Helen concluded, if it's an innocent breach, it can be remedied. So I think it's just important that directors always have this in mind, and hopefully they don't get in a situation where they are facing a claim. But it does occur. But yeah, I haven't got anything else to add. So I think that's it from us. And if anyone has any questions, then our contact details will be accompanying this podcast.
Yeah, thanks very much for listening.
Thank you.